I'm just going to look at the implications of this Kenyan court ruling. I'm just going to tell you the story, and I will have a guest in Barrister Alex Amujogu, who would give us an insight into the development. The High Court in Nairobi, Kenya, has ruled that the Kenyan government actively aided and abetted the abduction, torture, and illegal rendition of the indigenous people of Biafra IPOB leader Nnamdi Kanu to Nigeria in 2021. The court ruled that the Kenyan government flagrantly violated its own constitution and international legal obligations while aiding the illegal arrest of Kanu 4 years ago. Justice E.C. Nwita, delivering judgment on June 24, 2025, held that the covert operation to seize Kanu on Kenyan soil and forcibly transfer him to Nigeria was carried out with the knowledge, connivance, complicity, and tacit approval of the Kenyan authorities, including top security officials. The abduction of Mr. Nnamdi Kanu, the way it was done without due process, this incommunicado confinement while in chains, his treatment, including being denied basic necessities such as food and water, deny him access to medication despite requests, were acts that are outlawed by the Constitution of Kenya in 2010. In that regard, I find that and holds that there was gross violation of Mr. Nnamdi's rights and fundamental freedoms. Justice Nwita ruled. Let's just stop there, and talk about largely what this particular case means. I understand that he was awarded several amounts, to the tune of over, I think, 120 million naira, and that's like 10 million Kenyan shillings, and some other thing. To underscore the severity of the violations, the court awarded Kanu a sum of 10 million shillings, approximately 119.5 million Nigerian naira, in general damages against the Kenyan government. So one would wonder, really, are they going to carry this out? So let me come to you, Barrister. This is an interesting development from Kenya, because we've heard severally that this so-called rendition did not happen. One would wonder then, how did he fly into Nigeria? This is the very first time, and it's a landmark judgment of some sort that is laying clear what really happened 4 years ago. Do you think this would have any implications as to what is the trial that is going on in Nigeria?
In I view, the judgment of the Kenyan High Court is very commendable. It shows an judicial activism. The demands of judiciary is that they should be bold enough to say the law as it is. They should be bold enough to interpret the law as it should be and as it ought to be, no matter who is involved. Can you imagine that the judgment of the court, of the Kenyan judge, clearly in that the government of Kenya, that they fail to their responsibility and the duty they owe to a person who is lawfully in their country, that person and should be protected by the Kenyan government under their law, that allowing his right, freedom, by is not appropriate and should be condemned in totality. And the judge was mean and also in action awarded the Kenyan government for not securing the right of Nnamdi Kanu. The judgment is commendable, but it kettle of fish is on what effect it will have on Kanu's trial. To me, Kanu's trial in Nigeria borders on a criminal issue. It's a criminal case. The Kenyan judgment borders on it's an issue of human rights enforcement. Kanu has gone to court to enforce fundamental rights against Kenyan government for allowing that to against him. So the court have upheld that is on human rights basis. But Kanu is facing an issue of a criminal action that borders on terrorism. The only angle is an issue of a criminal action that
Go ahead,
the
please.
only angle in which the case may have a minor effect on Kanu's trial in Nigeria is on the issue of jurisdiction. On the issue of jurisdiction, because it is the Kanu's contention Nigerian court that what the government is alleging occurred against him is an act that was done outside the country. But following the trial in Kano, they are saying that Kanu was arrested in Lagos. So the federal government was tactical enough to try to confine of Kanu trial only. So their plan was, they are aware that if Kanu is reviewed from the federal government angle, jurisdiction, because a person can only be guilty of an offense in Nigeria if the offense is done and committed in Nigeria. So federal government tactically, in their evidence, they are now claiming that Kanu was arrested in Lagos, not in Kenya. So
Wow.
trying to find themselves that the trial is with the powers of the court to try him. So a duty is now on Kanu's counsel to prove that Kanu was arrested in Kenya. The offense in which he has alleged to have been committed was done in Kenya outside Nigeria. So they have claimed that they will file a notice of submission. In my own reasoning, that step that the federal government, that Kano's team intends to undergo of notice submission may not see the light of the day. Kano must enter his trial. But maybe one way or the other, count may be struck out for lack of proof, but that cannot terminate the suit. So in a criminal case, the criminal, that is the place of crime, is of a vital nature to determine whether the offense was committed or not, or should be tried in that. Kano's counsel, Kenya judgment, High Court judgment, to prove that the offense in which they are committed, maybe that in Kenya or outside Nigeria. Therefore, the students have linked it to a Nigerian offense of the judgment, not to prove that he was arrested in Kenya and not in Nigeria. But meanwhile, trial must go on.
But again, we've seen over time that even this matter of rendition has been adjudicated upon last year under the last administration, not even last year. I think under the last administration, and the courts, because of that matter, struck out the matter. But the federal government went and I don't know what they did, but they are still holding Nnamdi Kanu. If they're able to establish that Nnamdi Kanu was arrested in Kenya, just like the Kenyan court has announced, what then happens to the case?
If in one angle, the issue of to me as a lawyer, the issue of where Kanu, whether Kanu proves that he was arrested, to me, it may not have any fundamental threat against the whole charge against Kanu. Other counts, which government is claiming that occurred in Nigeria. So the issue of rendition or how he was arrested, these are civil, to me, these are civil actions. These are civil actions for damages, as it's being seen in Kenya. Even in Nigeria, I think they have damage against him in Nigeria. It may not have any fundamental in Nigerian criminal trial against him. So, and if you, and from the counts, Kanu is facing so many counts, and that counts borders on offenses that was claimed to have in Nigeria, whether in Abia or in Lagos or thereabout. So, it him to face an onerous task of proving whether what he was doing was an act threatening Nigerian unity, Nigerian. So that the trial cannot just end at this preliminary stage. It cannot end that. It must go through full-fledged trial to determine whether the alleged offense against him is true or false. So actually, on issue of Kenya, to me, does not have any fundamental on the criminal case, even though it will help to reduce the pressure him in the case, but can never terminate that criminal case against him.
Wow. All right. So as it stands right now, do you think Nnamdi Kanu is a political prisoner much more than a terrorist that they are tagging him with? Because again, you look at the whole scenario, and then you can't really point your hands at something tangible that you would say that the reasons why he's been held. Do you think that there's somebody who is playing a handball against him to stop him from being released? Because there are other rumors that says that he staying there gives a lot of persons a lot of monies daily. So I'm wondering what you think is going on with him right now, and how you think the Igbos generally have reacted to his incarceration.
Because in that area, the Igbo leaders have failed Nnamdi Kanu. The Igbo leaders have failed Nnamdi Kanu. That is the only way. This is a matter that ought to have been handled politically. Had it been that Igbos are united with one voice, there would have been a headway politically on his freedom. But because the Igbos are always divided, they are always divided. That is why he stayed there in custody. Just if you look at what is happening in other regions, Sunday Igbo, you see how he was almost arrested. Even in the Republic, you see how the Yorubas let on his behalf. Even his enemies, we are with him, that he can't be arrested or detained by the federal government. You see how he was released. Nobody see today. Nobody was heard about him because his people are with him. But in our own side, we are failing. We don't have leaders that has the common heart of their brothers at heart. What we have is political enemies who want you not to live, who does not want anything to grow in you. So the Igbos is a challenge to them that we need to have a kind of a rebirth in our freedom. It's important. Had it been that the leaders of our Igbo region are of one voice, the moment they rallied against rally for Nnamdi Kanu with federal government, I'm sure that Tinubu must hear their voice. But the issue is that our core leaders want him to be retained in custody. Not that he had an offensive issue, but because of what? Political interest. So it is a call for our leaders. Even Ohaneze has not done perfectly well on the issue. And who are the Ohanezes? They are the governors. That is Ohaneze. Their interest is always first and paramount. We should not be. We should see ourselves, even in Igbo language, they say, in our own local balance. But in our own case, Igbos are leaving their brothers in custody. They are even the one that are even pigeonholing you in this country. So it's very bad. It's very bad. Kanu cannot succeed fully with this legal process. Like that, let us continue to maintain man pressure on our leaders to embark on political solution to the problem. It's important. And speaking with one voice, there's no way Imo State Governor, Abia State Governor, Enugu and Anambra State Governor, Boy State Governor, there's no way they can come together and meet Tinubu asking for his release in custody. Tinubu, he can never say no. He can never say no. Because I am aware that Tinubu visited Anambra State some months ago. He visited Enugu State some months ago. He can even visit Imo State very soon. And none of them demanded for the release of Nnamdi Kanu. None of them had even mentioned his name on their plea. The federal government. It's unfortunate. It's too bad. Because of what? They are afraid, or they're not willing to do that. So had it been that they are of united voice, federal government will listen to them. They will hear their cry, they will hear their tears. But none of them is concerned about it. And we condemn that in totality. We must secure our borders. Right, human right is important. Human freedom is important. Let alone our own blood. So let the governments of Southeast, our leaders of Southeast, let them come together under one umbrella and make a full-fledged demand to the federal government for him to be released on their own political ground. And Tinubu must listen to them because of one voice. But my fear is that it is them that are keeping him there. That's the only problem. That's my only fear. Otherwise, by now, there must have been a solution to the problem which he has already encountered. That's my own reasoning. And we call upon them to do the needful before it is too late.
That the ruling
I, I can't get you very well. I didn't get you very well.
can you hear me?
Yeah, continue. Continue. Let me hear you. Let me get you. Let me get you again. Let me continue.
So the ruling party wants to use him.
I can hear you. I can hear you.
Hello, Barrister
I
Alex.
can hear you. I can hear you.
Okay. From Ndibos.
You know, there's no doubt that Tinubu, His Excellency, President Tinubu is a tactical politician. He's tactical in his political movements. Nnamdi Kanu sways populations, sways fans here and there, especially in Igbo land. And His Excellency Tinubu knew that the next election is somehow dicey. So he's tightening every corner to ensure that he comes for second tenure in office. It is possible for Tinubu to give you any gift, for him to give you any gift as a leader. He always wants a kind of a corresponding gift to himself. I'm sure that before Nnamdi Kanu can be released by the federal government, there must be a condition. There must be a written condition on where he wants him to go. So I won't be surprised that if they can make an offer to him to sign a condition that he will belong to the APC for him to be released. That is the only offer that they can listen to, and Nnamdi Kanu will be released. So because once it's released, Igbo population and voters, I'm sure it will change, because many followers want to even see him. They want to see him and hear from him. And once he says, because Tinubu has released him, that we should vote for Tinubu, it will sway many voters to his own side. So it will be a kind of maybe before the next election will occur, with some months to the election, people may use that political formula as an angle to dismantle the Igbo race in his own side. Because Tinubu, to me, if you watch Tinubu's political footsteps, Tinubu is a mean to come back for second tenure. It's determined, and he's ensured that no stone is left unturned to ensure his return. So he must do something. He must do something for the Southeast or for the Igbos to ensure that they are in the same page with him. And the only formula that he can use against Peter Obi is Nnamdi Kanu. That's the formula that he can use against Peter Obi is Nnamdi Kanu. So once Nnamdi Kanu is released in custody, it can change the atmosphere politically. Can change the atmosphere politically. So, but I'm seeing that it may occur some months to the election. Not now, not this year. Maybe from next year, we may see some positive results coming from that political angle. So Nnamdi Kanu's case is never a case that should be allowed to go to be resolved legally to the end. Rather, our leaders should ensure that it is being resolved politically before the final judgment. Otherwise, it will not augur well for the Igbo race. So we must endeavor to ensure that things are done properly. That one Nigeria we claim to be is given to everybody. You see how the case of Dokubo of South was resolved politically. You see how Igbo case was resolved politically. Mustafa was resolved also politically. So our own should not be a different kettle of fish. We must also embark on that formula to resolve our predicament against Nnamdi Kanu in a political platform and political way to ensure a free and fair election in future. So Tinubu will always utilize every opportunity to garner votes in any region. And this case is a test case for him.
I mean, there's so many sides to this particular story, and it's interesting how far we've come with this case, and it doesn't look like there's an end in sight to that to another country. You know, about stopping and with the person who was moved from one place to another, their will has now committed crime.
Right? I didn't get you very well. It was cracking. I I didn't get you very well.
No, okay. Well, can you hear me now?
Let me hear the question again.
Well, can you hear me
Yes, I
now?
can hear
Can you
you
hear me
now.
now? That like we see in Kenya. I mean, what does it look?
I can hear you. I can hear you. I can hear you now. So say it again.
I say, what was what does the law say about internationally rendering somebody?
And to me, issue of issue of
Oh wow.
issue of rendition. Issue of rendition to me, it is an issue of international law. International law. You know, there is what we call the sovereignty of nation. Sovereignty of nation. Every nation is independent. Every nation has an international treaty that they are bound. Are you hearing me?
Yes, I can hear
Okay.
you.
Every nation has an international treaty.
Go ahead, Alex. Go
I
ahead.
said the issue of rendition is an international principle of law that nations are bound by. Every nation always seeks to protect their integrity and sovereignty and independence. So any attempt by another nation to interfere in the affairs of another nation will be a breach of international law if you did not get the appropriate permission from the country where you are intervening in. So under the law, for you to abduct, for you to carry somebody, arrest somebody from another country in another country, there must be some procedural requirements that the law requires you to follow. Don't just enter another country, another man's country, and make any arrest or detention. You must have followed a procedure that the law has made it very clear that you must follow. So in a nation, it is important that any person who you feel committed an offense in your country, as another country, you must have sought for an order of court in that country. You must have gotten a court order. You must have sought for an order of court in that country, seeking for rendition to your own country, where you want him to be tried. So it is wrong for the government of Nigeria to just enter into Kenya to ensure an arrest has been made to arrest Kanu and bring him back to Nigeria without a valid court order. There must be a valid court order for such an arrest to be made in another country. So, in Nnamdi Kanu's case, there is no court order, there is no procedure, there is no format which the international law requires a country or another country to abide by before any arrest and transfer of a suspect to be made. That is the issue. So there was no court order. There was no approval. That is why the High Court judgment in Kenya accused the government of Kenya for religion in their duty because they allowed that elaboration to occur. It is very wrong. They wouldn't have allowed Kanu to be arrested and forcefully taken back to Nigeria without any court order. It is a wrong procedure in which they are bound by to comply with. So the court was not comfortable, not happy that the government of Kenya failed in their duty. They failed in their duty to protect and safeguard citizens' rights and freedom. So that freedom is very important. You don't just ambush somebody on the way, who's in another country, and bring him back to Nigeria. It is very wrong procedure. It is a very long procedure. There must have been an application to the government of Kenya that they want to make an arrest or that he should be arrested and bring back to Nigeria. And that request should be approved by the court of law. There should be an order of court that gives that permission for him to be arrested. Otherwise, whatever arrest you have made is illegal. It's against the law and shouldn't be condoned. So the judgment of Kenya High Court was an umbrella to safeguard procedure. It is an umbrella to safeguard the rule of law. It's an umbrella to safeguard freedom of movement and liberty. So that next time, there shouldn't be a precedent for somebody to be arrested anyhow because another country wants him to be arrested. It is very wrong procedure. So there should be a format, there should be a procedure which you have already undergone before an arrest and the transfer of suspects to another country will be made. So in all, we are saying that international law forbids another country from coming to another country to make any arrest or ensure a person is arrested and transferred to another country without following laid down procedure, without following any approval of any court of law in that country. That's the summary of it.
Stands now. I don't think they have ever had a meeting We've seen them have meetings on several things. Ohanes Ndi to read the communique by the Imo State governor. It is something that upon and just after speaking to. But I'm just wondering, for you as a barrister, at this time that we are in now, we're talking. Kanu will be filing case submission this July. Is there anything that looks to you like, it's a
Is there what? It's a, what's the question?
I said that the Nigerian court about Nnamdi Kanu. Can you hear me?
What's the question?
Can you hear me?
What is the question you're asking now?
Can you hear me?
I'm hearing you now. Yes.
Okay. Going on in this.
Is it case? Is it no case submission?
Alex, that he filed against the federal government.
Nnamdi Kanu's trial have been adjourned for no case submission.
Yes.
Have been adjourned for no case
Yes.
submission. So that is why I'm saying that. Are you hearing me?
Go ahead.
I said Nnamdi Kanu has been adjourned for no case submission. And a no case submission means that from the evidence already adduced before the trial court by the complainant's witnesses, that from the evidence they have laid bare before the honorable court, that there is no offense had been committed by Nnamdi Kanu. So that even if the court want to adopt whatever the witnesses have already said in that case, that there is nothing that links Nnamdi Kanu to the offense in which they say that he has committed. That is the no case submission. That he has no case to answer from the evidence already adduced before the court. So, and a no case submission is that there is no need for Nnamdi Kanu to come and defend himself in court, because from the witnesses already testified in court that they have not established any case against Nnamdi Kanu that will warrant his entering an appearance or defending himself in that court. So, but we are saying that in my own reasoning, even though that one or two counts of the offenses against Nnamdi Kanu, they may succeed in a no case submission, but not in all. Not in all. There's no way that criminal case can be finally be determined on a no case submission. There's no way. Rather, that criminal case must go on a full-fledged trial, especially with this high court judgment of the Kenyan court. That judgment of the Kenyan court is not before the trial court now. It is never before the trial court in Nigeria. It is never. It is only when Nnamdi Kanu enters his defense that he can now tender that high court judgment of Kenya. But as for now, that judgment of Kenya is not before that high court judge in Nigeria, because they have not yet an exhibit an issue before the court. That is why that it will now be a burden that Nnamdi Kanu must enter trial. He must defend himself. Then he can now tender that High Court judgment of Kenya to establish that he was never in Nigeria when the alleged offense was committed, but he is staying at outside the country. That's what is called a plea of alibi. A plea of alibi is what's called in law. But you are not there when the offense was committed. A plea of alibi. So plea of alibi will be a defense to Nnamdi Kanu when he enters into trial. It is only when he enters into trial that he can establish a case of plea of alibi, because he was not in Nigeria when the alleged offense of killings or sit-at-home Monday sit-at-home was being done. And you can never convict a person who is not in Nigeria for an offense done in Nigeria. He must be in Nigeria for you to have power or jurisdiction to try him in Nigeria. So, in a nutshell, we are saying that that no case submission will not, with respect to the defense counsels, it will not see the light of the day. It never succeed. Rather, even though it will help to reduce tension, but it can never achieve the intended result of no case to defend. There must be a full-fledged trial, wherein the defendant, Nnamdi Kanu, will now lay bare how he was arrested. We now lay bare how he was detained. We now lay bare how he was denied food or how he was treated while in Kenya or before coming to Nigeria. He will now lay bare that he was not in Nigeria when the alleged offense was committed. He will now lay bare in his evidence. He is the only man that can say whether he was there, whether he was not there, or whether he did the act, whether he did not did the act. So he must defend himself. So instead of delaying the matter for more, he should just quietly go and defend himself. Even though that delay will only give room for a political solution to the problem. Maybe in due course, you can seek for ADR in the course of the trial. But basically, a local solution cannot solve the problem for him in this trial. That is my own reasoning as a lawyer.
What is AADR? Alternative Dispute Resolution?
Yes, that is the political process of solving the problem using political means, as we are saying before. That this delay, the delay in trying him, can be an avenue for our Igbo leaders to come together again and speak with one voice. I've said it here. How would you be telling me that individuals will be going to meet Tinubu? You should release Nnamdi Kanu for us. It's wrong. The governor of Anambra State has gone to Tinubu or even pleaded in a rally that he should give Nnamdi Kanu to him. No, it is wrong. Ifeanyi Ubah, when he was arrived, I've seen Tinubu that he should be released to him. It is wrong. They should come together as one body and make the movement. Or a day should be fixed. There should be a day. If they are serious with their demand, a day should be fixed in which the Southeast governors and the other Igbos, our senators in the assembly, they should come together on a particular day and pay a visit to Tinubu, His Excellency, our president. If once they come together as a body, not individually, once they come together as a body and make a full-fledged demand using that political means of joining APC, they will release him. But they have not been able to gather that muscle to come together and make this demand. They have not been able to do that because of what? They are the one holding him. They are the one internally and inherently holding him. Otherwise, if they come together as a body, fix a particular date with approval, and make a movement to Asolok, sure and sure, Tinubu must listen to them because they are all big wigs. They are all stakeholders in the system. And meanwhile, Tinubu wants collaborative effort to ensure his second term in office. He wants that result. So once they can come together and make an offer, that they should give him to them. Then that they will also support him in the next election. Tinubu will do that. But meanwhile, they have not been able to have that political will, political muscle, political initiative, or the determination to make him to be released. They are seeing that if he's released, it will create a divergent followers. That they are fear. That it can cause them some political structure in their own state. So it's better and for them to be safe. Let him remain there. Let him remain there. And that is the purpose of their willingness to follow that matter to the logical conclusion. So they are seeing him as a threat to their structure. These are his followers. But once they remove that fear of political structural dislocation, it's possible that it can be done. It's possible. But my fear is that they are afraid of that political dislodgement within their structural background.
If he eventually gets released, do you think it will affect the 2027 elections? And how do you think it might affect it? Is it going to be to the advantage of opposition or to the advantage of the ruling party? How do you read it?
Nnamdi Kanu cannot be released. He cannot be released without APC leaders in Southeast being the leader, that is, being the arrowhead behind his release. You cannot. There's no political leader in Igbo land that can meet Tinubu to release Nnamdi Kanu without an iota of APC being the initiator. Charles, once Hope Uzodimma, just Hope Uzodimma, Dave Umahi, other static governors, once they come together using the umbrella of APC, to make a demand to Tinubu that this is their gift, that this should be a gift to the Southeast for them to garner APC in their favor. Once they make that sole demand, Charles, you will see that Nnamdi Kanu, if he is released, he will support Tinubu. He will support Tinubu.
Oh, really?
And meanwhile, let me tell you, Nnamdi Kanu has undergone several pains. By now, he has been injured emotionally, psychologically, physically, mentally, and otherwise. He is now as a human being, he's in a depressed move. So once these governors or these leaders visit him and ask him that he should join APC, which is leading government in Nigeria now, for him to be released, I have no doubt in my mind that Nnamdi Kanu he will accept that offer. He will rejoin APC. Because of what? Freedom is important. Freedom is it is a product that is priceless. So once you offer somebody freedom, he will be in a hurry to grab that freedom. We are calling on the APC leaders. Had the gathering members in the defection, let them gather Nnamdi Kanu as a part of the defection process. Let them gather that defection spirit towards Nnamdi Kanu. He will defect to APC because now he has been in a pain that can be relieved through defection. And having known his weight, political weight and followership, Charles, they will be in a hurry to accept him. They will be in a hurry to accept him. But those who should lead him to Tinubu, they are not leading him to Tinubu. That's the problem you're having with him. Those who should lead him to Tinubu are not in the forefront of leading him to Tinubu. I don't know why.
And because they are also scared about losing their own structure.
That's the thing. That's the only reason. So had they been not afraid of their own structure, and meanwhile, And meanwhile, they have seen that Nnamdi Kanu has suffered an indelible pain from these leaders. Just, there's never a time Nnamdi Kanu can forget what happens to his family when he was ambushed. He can never forget that incident. Is the reason for all these problems. Charles,
Right.
that event is very excruciating. That event is very inhumanizing. It's an inhuman treatment. Life, we are lost. And not even lives. Personal lives, we are lost. Things we are destroyed. And life is precious. No amount of money, even 1 billion naira, can never buy life. So Nnamdi is aware about the agony he encountered. Even those who committed the act of that ambush, they are aware that Nnamdi Kanu knew that they are the sponsor of that event that he even led to his father's death and others. Many have been killed. So issue of life made them to be afraid of releasing him because he is aware that the holders are aware that once he's released, that he can never forget what happened to his father, what happened to his mother. That pain can never be forgotten. So it is the fear. It is the fear of the stakeholders who spearheaded that invasion that is now putting them also in fear. That it will be a danger on their own part. If the same man want to kill now comes back to us to stay with us. So that's a double fear. That's a double fear. So we are in a dilemma. We are in a dilemma. It's unfortunate. Even though that Bible said that we should forgive one another. We should forgive. But I'm not sure. The nature of Nnamdi Kanu, he is a man that can never forgive. From the way I'm seeing him, he's a man. They knew that he's a mean man. He's a strong man, a man that had a strong heart, that can never easily forgive an event, especially that one that affects you. Even that event, he has already also seen his death. Nnamdi Kanu saw his death. He miraculously escaped that invasion. Miraculously. Many lives were wasted. And that was done by his own people. I don't know anywhere in Nigeria. I've not seen anywhere in Nigeria where that kind of invasion can happen. In Yoruba land, in Hausa land, in middle belt. I've not seen that. It's only in Igbo land that we can tell our enemies to come, that we know how to get our own blood. It's only in Igbo land that we can tell our enemies, come, we can help you get our own brother. That is the problem we're having in Igbo land. It's very unfortunate. We should have to rethink in our mind that blood is more than money and connection and post. We should love your neighbor, love your blood, Don't waste people's blood because they are your own people. Our strength should be shown outside. Whenever I see where we are in Nigeria, I normally weep because we are living the sensitive issues in Nigeria and deploying our energy inside our own self. In the armed forces, in army, okay, what is the issue now? Charles Nnamdi Kanu is a messenger that preaches on the issue of attack, killings in Igbo land, forest invasion. That is his message. These are visible issues that those in charge of Nigeria should condemn. The attack. People are being killed. Homes are being invaded. Women are being raped. Farmers are crying. Farmland are being destroyed by headers, and nobody is condemning it. Somebody is now saying that it is wrong to allow foreigners to invade people's farmland, kill their crops, kill their women, kill their farmers, and go away even they capture their land. Somebody saying it is wrong. Your own people are saying you shouldn't say that. Your own people saying you shouldn't say that. You see even those who are doing that act, the Fulani headers, the dangerous headers. Have you had any of their brother condemning their action in Nigeria? Instead, anytime you touches any of the Fulani headers, whom you claimed invaded people's land, their leaders will come out and condemn you. They will come down and condemn you. Eh? I said,
True.
they don't talk with their own blood. That's my message.
True.
So, Charles, you see what happened in Benue State. In Benue, you see how the headers, the military are there for the Fulani military. How they killed, when I had it, almost every week they were killing people. Killing 100, killing 250. People's life being wasted. And have you had any Fulani leader in the north asking the Benue people to go and kill the Fulani people? No. What they would say is that, what they will tell you is please call for dialogue. That's what the message they will give you. Go for dialogue. But in our own country, in our own Nigeria, in Igbo land, we are the one that we even tell the
Barrister, since we've lost the connection with Barrister Alex. Okay, Barrister, are you there?
Yes, I'm there. Okay. Are you hearing me now?
Yes, I am. I'm hearing you.
So I'm saying that we should look at how others are Nigerian issues. In Benue, not only intense.
In hundreds.
The military then who came to Benue, they are killing people almost every week. And you have not had any Fulani leader in the north asking the Benue people to go and use cutlass and shoot everybody. What they will tell you, whom they have injured, whom their people injured, is let there be dialogue, let there be peace, let there be dialogue, let there be meeting for peace. Therefore, thereby trying to protect their people. But in our own platform, in Igbo region, whenever you see any forest guard people killing Fulani or killing any invader in the bush, what you will see that our governors, our leaders, will tell the soldiers to go and shoot. Wherever they are, they don't even know the reason. They won't even they won't call for a meeting to know why they are killing the dangerous headers. So we need to get it right on how to resolve Nigerian issues. We shouldn't be betraying ourselves while we are suffering. We should follow others so that we have a full-fledged one Nigeria. But it's very unfortunate that we are against ourselves. And that is
Barrister, we are wrapping
back.
All right, but Barrister, we're wrapping up now, and I just wanted to ask you, why do you say that Nnamdi Kanu will join APC as soon as he comes out? And I mean, he's not going to be held incommunicado for forever. At some point, he's going to be released. And you said that it seems that Nnamdi Kanu already knows people who are still keeping him in jail. So I'm just wondering, why do you think the dynamics will play in such a way that when he comes out, he will support the APC?
With the way things are now in Nigeria, with the way things are now in Nigeria, Nnamdi Kanu can only be released politically before his trial. It is only when he joins the APC, because there are the people in government. Even as Osimodo said, that once you join APC, your sins are forgiven. That's like somebody going in for confession. Actually, don't Tinubu can never listen to anybody. He can never listen to any person seeking for bail of Nnamdi Kanu without you showing a sign, giving him a rationale for his release. He must have seen the political need for something to be done, and that need is that he has that man he had agreed to join the movement to support his second term agenda. That's the only reason he can hear. Otherwise, he will remain. His trial is which can be judgment left or right. But from the nature of the case, this is not a case that can easily go away. And the federal government is following it up. It cannot easily go away. There must be a delay. Even if the High Court, you don't be surprised. Even if the High Court charges him, they will detain him again for why on appeal. So they must ensure that he's on track until they finish their election in 2027. So that's the only shortcut for Nnamdi Kanu to make a move of freedom and liberty in Nigeria. Thank you.
All right. Thank you so much, Barrister Alex Amujogo. I mean, we are just an hour on top of on all of these broadcasts. I want to appreciate you. This is our first discussion on YouTube. I hope that other discussions will crop up, and we would call you up for these kinds of discussions as we build up to the 2027 elections. I want to appreciate you again, Barrister Alex Amujogo. Thank you again for your time.
Thank you for having me.
You're welcome, sir.
I'm grateful.
All right. You're welcome.